Small claims. Trial. If you were not able to resolve your small claims dispute before your court date, you will need to go to trial. Small claims trials are more informal than civil trials, and many of the rules of evidence and procedure have been relaxed. Small claims trials are very brief and generally only last around 15 to 20 minutes. You cannot have an attorney to represent you at a small claims trial. In general, the parties must represent themselves in small claims court. However, there are some exceptions. To appear on behalf of another party, complete the Authorization to Appear, Form SC-109, and either file it before the court date or bring it with you to the court hearing. What to expect on your court date. The date, time, and location of your trial will be on the first page of Form SC-100. Allow plenty of time to find parking and get through security. When you arrive, go to the courtroom you were assigned to and check in with the bailiff. Before the hearing, the courtroom procedures are explained either by the judge or by a court officer. The court will call roll to see which plaintiffs and defendants are present for their hearings. All parties present will be sworn in. Listen for your case. The cases are not always called in the order listed. When your case is called, stand at the table or podium. The plaintiff will speak first. The defendant will have a chance to respond. When presenting your case, stick to the facts. Be brief. Start with your strongest arguments. Speak in a calm voice. Tell the truth. Summarize your case. The judge may ask questions. The judge will hear both sides of the case. Both parties will be able to speak and tell their side. The judge may make a decision that day in court, or the judge may take your evidence under submission, meaning that the judge will review your evidence and issue a decision at a later date. You should receive your judgment in the mail in about 3 weeks. Bring any evidence you will need to the trial. Keep everything organized. You may want to have a binder or folder. Bring 3 copies of everything you would like to present. One for you, one for the judge, and one for the other party. You can subpoena documents that are in the possession of another party by using a small claims subpoena, Local Form L-520. Examples of things to bring to court include copies of correspondence or conversations between you and the other party, such as texts, emails, or letters. Be sure to print out any text messages from your phone. Copies of contracts, rental agreements, receipts, canceled checks, etc. If you have photographs, be sure to print them out. You can bring witnesses to the trial. A witness is someone who has first-hand knowledge of the events. You may subpoena a witness if needed. Or you can ask the witness to provide a signed statement. Be sure the witness signs their statement under penalty of perjury of law. On the bottom of each page, the witness must include the following statement: I declare under penalty of perjury, under the laws of the state of California, that the foregoing is true and correct. A subpoena, Form SC-107, is needed if you need a witness to testify on your behalf, or if you need documents that are under the control of someone else. A witness is entitled to witness fees if requested. If you subpoena documents, they will either be brought by the witness to the court or be sent to the court and available on the trial date. Complete these steps to issue a small claim subpoena. First, fill out page 1 of the small claims subpoena and declaration, Form SC-107. If you are requesting documents, be sure to complete Section 4 and select whether you want the witness to appear in person with the documents or send them to the court. If you are requesting documents, You must also complete page 2 and specify the exact documents and explain why good cause exists for the production of the documents. After you complete page 1 and 2, you or someone else must serve a copy of Form SC-107 in person to the witness. The subpoena is the only form you can serve yourself. The server must complete the proof of service on page 3 and return the original Form SC-107 to the court before your hearing date. Courts often use temporary judges, called judges pro tem. A temporary judge is an attorney who has been licensed for a minimum of 5 years to practice law in California. Each temporary judge is required to complete a training program before hearing cases. All parties must give their consent to be heard by a temporary judge. If you do not consent, notify the court before your hearing. The clerk may reschedule the hearing to a later date when a regular judge or court commissioner is available. Interpreters. If you need an interpreter, you should arrange for an interpreter to come on your behalf at the trial. Do not ask a child or a witness to be your interpreter. You may be able to request an interpreter from the court based on availability. Go to the court's website for more information. If you need an accommodation for a disability, contact the court's ADA coordinator at least 5 days before your trial date. For the deaf or hard of hearing, there are American Sign Language interpreters and real-time captioning for parties and witnesses. To request an accommodation, complete the request for accommodations by persons with disabilities and response, Form MC-410, and file it at the court before your hearing. You should give the court at least 5 days' notice whenever possible. Go to the court's website under ADA for more information. At the hearing, you may ask the judge to award your costs if you win. Costs are awarded at the judge's discretion. However, many judges will award court costs automatically to the winning party. Be sure to keep receipts for your filing fees and other costs. Costs that may be recovered include court filing fees, service fees, if reasonable, witness fees, but generally not for expert witnesses, and fees for service of subpoenas. For more information, contact the Orange County Small Claims Advisory. To learn more about your options after trial, go to the next section.